In the heart of Florence, a city brimming with art, commerce, and intrigue, a legal battle was brewing. It was a story of family, money, and the complex web of laws that governed the lives of its people. At the center of this storm was a dowry, a sum of money or property given by a bride's family to the groom upon marriage. But this wasn't just any dowry. It was a dowry that had been lost, and now a cousin, who had stepped in to pay it back, was demanding his right to the property that had been pledged as security. The year was 1403, and the city of Florence was a bustling hub of trade and culture. But beneath its vibrant surface, a legal dispute was simmering. A young man, we'll call him B, had married a woman and received a dowry of 600 florins. However, B's father had left a will that placed certain properties under a special obligation, known as a fideicommisum, which meant these properties could not be easily sold or transferred. When B faced financial troubles, his cousin C stepped in and paid the dowry to B's wife. Now, C wanted to claim the property that had been pledged as security for the dowry. The lawyers of Florence were called to weigh in on this complex issue. The first group to tackle the case was a formidable team of local legal minds: Filippo Corsini, Bartolomeo Popolski, Riccardo del Beni, Antonio da Romna, and Giovanni Serristori. They were all respected figures in the city, with Filippo Corsini being a leading oligarch and a tough old lawyer. Corsini began by arguing that the law, specifically the Authenticer res qui, allowed for the alienation of property that was otherwise restricted if it was needed to meet a dowry obligation. He pointed out that the law was designed to encourage marriage and benefit the city by ensuring that families could produce children. Corsini's argument was that the same logic should apply to the return of a dowry, not just its initial provision. The other lawyers agreed and added their signatures to Corsini's opinion, lending their weight to the argument. Riccardo del Beni, for example, noted that the cousin who had paid the dowry was acting out of kinship duty and should be entitled to the property. The lawyers delved into the intricacies of grammar, logic, and family relationships to make their case. However, the story didn't end there. In 1413, a new group of lawyers was brought in to review the same case. This time, the roster included Nello Cetti da San Gimignano, Ruggiero di Niccolo d'Antonalla, Paolo di Castro, Pietro d'Ancarano, and Floriano da San Pietro. Unlike the first group, most of these lawyers were outsiders, brought in from other cities like Siena and Bologna. They were respected jurists and teachers of law, and their opinions carried significant weight. Nello Cetti, the first to speak, acknowledged the previous legal opinion and agreed with it. He argued that the law should protect the surety who had paid the dowry, especially since the husband had faced financial troubles, including being kidnapped and having a ransom paid. Nello's argument was that the general obligation to return a dowry should not be nullified by a fideicommisum, and he cited several texts of civil law to support his position. Ruggiero di Niccolo d'Antonalla added that the brother who had also stood as surety for the dowry should have his future and present property bound to the obligation. Paolo di Castro, a prominent legal figure, offered additional arguments, emphasizing the importance of fairness and the protection of sureties who acted out of generosity. The outsiders, while not as familiar with Florence's local laws, showed a deep understanding of the city's legal practices and the broader principles of civil law. They were careful to reference Florentine statutes and the specific context of dowry instruments in their arguments. As the lawyers presented their opinions, it became clear that the issue of dowry restitution was not just a legal matter, but a social one. The protection of sureties was crucial for maintaining the marriage market, as no one would be willing to stand as a surety if they had no recourse in case of financial loss. The case of the dowry and the surety's right to recovery continued to be a topic of debate, and it eventually led to the revision of Florence's statute on dowry restitution. The new statute, influenced by the opinions of these legal minds, provided more detailed provisions to protect sureties and ensure that they could recover what they had paid. In the shadows of Florence's grand palaces and bustling markets, the legal battle over the dowry raged on. But for the lawyers and the surety who had stepped in, the fight was about more than just money. It was about justice, fairness, and the complex interplay of law and society. In the bustling city of Florence during the late 1300s and early 1400s, the role of lawyers was more than just giving legal advice. They played a significant part in shaping the city's laws and ensuring that the government followed the rules. However, their opinions weren't binding like court decisions. Instead, they could influence new laws by highlighting important legal issues. Florence, like other Italian cities, was very protective of its laws. They didn't want judges to change the laws just because they thought something was unfair. But lawyers could still impact the law by suggesting changes. For example, in 1415, Florence updated its laws, and lawyers like Paolo di Castro and Bartolomeo Volpi were involved. They worked under the supervision of 5 important citizens, known as the Monte officials, to make the laws clearer and more consistent. Paolo di Castro, in particular, had a big influence. He was well respected and gave the new laws a solid legal foundation. This was especially true in areas like marriage, inheritance, and family law, which were closely tied to the broader legal system known as ius commune. Other lawyers, like Alessandro Bensiveni and Tommaso Salvetti, wrote detailed explanations of these laws, drawing on the advice of earlier and contemporary legal experts. Lawyers also helped protect people's rights, even when it meant going against the interests of powerful families. For instance, they ensured that widows could get their dowries back, and that sureties, people who guarantee a debt, could be reimbursed. These were important because they helped widows and sureties maintain their financial stability, even though it might reduce the wealth of the deceased husband's family. When it came to state matters, lawyers could hold the government accountable. They could challenge actions that violated laws or the rights of citizens, especially those based on ius commune or Florence's own laws. This was important for maintaining the rule of law and ensuring that the government acted fairly. One of the most important legal tools of the time was the concilium, or legal opinion. These opinions were like detailed legal advice that jurists gave on specific cases. They became very popular in the 1400s, and they played a crucial role in spreading the principles of ius commune. University-trained lawyers learned to apply their knowledge to real-life situations, making the law more practical and relevant. However, lawyers didn't just focus on ius commune. They also considered local practices and traditions. For example, the use of sureties in dowry agreements was a common Florentine practice, and the city's laws included specific provisions to protect these rights. In the late 1300s, a famous jurist named Baldus de Ubaldis wrote an opinion about a critical legal issue in Florence. He questioned whether the city had the authority to charge people with treason, a serious crime against the state. This was a complex issue because, while Florence could certainly punish people for rebellion, the charge of treason was usually reserved for crimes against the highest authority, like the emperor. Baldus's teacher, Bartolus of Sassoferrato, had previously argued that only the emperor could charge someone with treason. He believed that cities and kings, while they could punish rebellion, didn't have the same level of authority as the emperor. Baldus, in his opinion, followed a similar line of thinking. He suggested that while Florence could punish conspirators for sedition, it couldn't charge them with treason in the full sense of the term. This was a significant point because it limited the power of the city government and emphasized the importance of the rule of law. It showed that even in a powerful city like Florence, the government's actions had to be grounded in legal principles and couldn't just be arbitrary. In the late 1370s, Florence faced several conspiracies. One plot involved a group of elite citizens who planned to cause a disturbance and bring back exiled leaders. Another, more serious plot involved a band of exiles working with foreign allies to overthrow the government. The Florentine government, led by the Capitano del Popolo, worked hard to uncover and suppress these plots. Baldus's opinion on treason was particularly relevant in this context. It highlighted the need for legal justification in handling political crimes and showed that even in times of crisis, the law had to be followed. This was a reminder that the government's power, while strong, was not absolute and had to be exercised within the bounds of the law. In the cold, wintry days of December 1379, the city of Florence was gripped by fear and suspicion. John Hawkwood, a mercenary captain, had learned of a dangerous plot that threatened to tear the city apart. For a hefty sum of 12,000 florins, Hawkwood revealed that Guelph exiles and disgruntled Ciompi, a group of lower-class workers, had gathered near Bologna. They were arming themselves and planning to retake Florence with the help of Gennaro da Salerno, a powerful ally. The news sent shockwaves through the city. The priors, the highest officials of Florence, were informed, and they sprang into action. A letter from Count Antonio of Montebruscoli confirmed that the plot was set to unfold on the night of December 19th. The government quickly dispatched the forces of the Auto di Guardia, the city's new police force, to hunt down the suspected conspirators. When the conspirators were captured, the Capitano and Executor, the city's law enforcement leaders, were hesitant to condemn them. This reluctance sparked a heated assembly, where citizens and guildsmen demanded justice. Alessandro di Benedetto Gucci, a prominent citizen, called for the guilds to take matters into their own hands if the rectors refused to act. The room was filled with angry voices, and the pressure mounted. Eventually, the guilds gave 4 citizens the power to carry out justice, and the Capitano was forced to comply. The executions began. By the end of the week, over a dozen men had been beheaded, including Piero di Filippo degli Albizzi and Filippo di Biagio degli Strozzi, both influential figures in the city. The executions were swift and brutal, and even some supporters of the government, like Martian di Capo Stefani, had doubts about the fairness of the proceedings. Stefani, who was serving on the priorate at the time, questioned the execution of Donato Barbadori, a man who had once defended Florence at the court of Pope Gregory XI. The government, now more determined than ever, demanded pure and undiluted justice. Calls for the confiscation of the conspirators' property and the punishment of their families grew louder. Tommaso Strozzi and Giorgio Scali, key figures in the government, pushed for a rigged election to ensure that only loyal priors would be chosen for the next term. In January, the Capitano, based on confessions from the executed conspirators, condemned nearly 50 more people for their involvement in the plot. These individuals were from the ranks of the Albizzi faction and the radical Ciampi. The government had successfully eliminated its enemies, but the seeds of rebellion had already been sown. Outside the city, in the areas where mercenaries and exiles roamed freely, a new conspiracy was taking shape. These conspirators, now declared betrayers and rebels of the Commune of Florence, were at war with their city and could be killed without trial. The legal system in Florence, already strained by the recent events, faced a new challenge. Baldus Diubaldes, a jurist who had taught at the Florentine studio and was familiar with the city's customs, returned to Florence and wrote 2 opinions on the December conspiracy. The second of these, written by Baldus himself, is particularly significant. Baldus began by addressing the nature of the crime. He explained that while maestas or majesty could be attributed to God, the emperor, the Roman people, and the king, it did not apply to cities or political faction. Florence, being a municipium, or a city with some autonomy, did not possess the same majesty as these higher entities. Therefore, the crime committed by the conspirators was not treason but sedition. Sedition, Baldus argued, is the act of conspiring to betray or overthrow the public and good government of a city. It is a serious crime, punishable by death, but the law also allows for clemency in certain cases. Because Florence is governed by its own statutes, the rectors had the discretion to choose the appropriate punishment. Since the sentences did not include the confiscation of the conspirators' goods, Baldus concluded that no additional penalties should be imposed. The government's actions, driven by fear and a desire for control, had serious legal and ethical implications. The judicial process, subverted by the anger and fear of the guildsmen, had led to a situation where those captured and executed found themselves outside the protection of the law. The government's decision to seize the property of the condemned and punish their families was a stark reminder of the power and the dangers of the state. The events of December 1379 and January 1380 marked a turning point in Florence's history. The city's government, now more entrenched and ruthless, had shown that it would stop at nothing to maintain its rule. The conspirators, though defeated, had left a legacy of defiance that would continue to haunt the city for years to come. Baldus's opinion was a masterful blend of supporting and challenging Florence's authority. He argued that Florence didn't have the grand status. Maestas needed to impose harsh punishments like delayed confiscations on the conspirators. However, he didn't undermine the overall authority of Florence, which was considered as powerful as Rome in many ways. By keeping a clear line between common law, ius commune, and Florence's own laws, Baldus found a way to support the rule of law. He believed that governments, just like citizens, should follow their own laws and procedures. Florence could have made laws that allowed for harsher punishments, but it didn't, and Baldus insisted that they couldn't change this after the fact. This showed that Florence's power was limited by the laws it had set, creating a paradox where its authority restricts its own actions. Less than a year after a plot against the government was quashed, another crisis hit Florence. On September 15, 1380, Giovanni di Mon, a Florentine ambassador, was murdered in Arezzo. Giovanni was a respected figure who had served in important roles, including as a prior and a gonfaloniere. His murder was seen as a disgrace, as no other ambassador had ever been killed by Florentines before. One of the killers, Tommasino da Panzano, had arrived in Arezzo with Charles of Durazzo, who was considered a public enemy. Charles brought an army and several Florentine exiles, who were part of the earlier plot to overthrow the government. When news of Giovanni's murder reached Florence, the government was outraged. They called it a heinous crime, and declared the killers to be sons of Satan. They promised to punish the killers severely, and even threatened to punish Tommasino's male relatives if he wasn't caught within a year. Giovanni's funeral was a grand public event, but the punishment had to wait. Florence feared war with Charles and agreed to pay 40,000 florins for peace, which included a promise that Charles would no longer harbor Florentine exiles. The murder was finally avenged on January 20th, 1381, when Giovanni di Luca da Panzano, Tommasino's cousin, killed him in a Sienese inn. Giovanni, hoping to avoid becoming a rebel himself, was promised a reward for his act. The government praised him and gave him the reward, stating that Tommasino had become a rebel and thus could be killed. This event showed how the turmoil of politics could even break family ties. In a legal opinion, Baldus addressed whether Giovanni should be rewarded for killing his cousin. He argued that killing a person who is an enemy of the state is not fratricide. Instead, the killer is seen as protecting the city and should be rewarded. Baldus explained that the kinship between Giovanni and Tommasino was annulled because Tommasino was an enemy of the state. This was different from a situation where someone is banned for a private offense. As in those cases, kinship still matters. Baldus's opinion highlighted that the question of whether Florence had the authority, maestas, to be the object of treason, was still open to interpretation. Despite the threats to the Florentine government, the commitment to the rule of law was fundamental. Jurists like Baldus were asked to resolve complex legal issues, blending principles of law with practical solutions. Their work showed that even in times of crisis, the law could provide a refuge and maintain dignity. In Lucca, a small republic near Florence, the concept of lesa maesta's high treason played a crucial role in preserving its political and institutional identity. Lucca, known for its love of freedom and independence, had a unique status as an imperial city, recognizing the emperor as its superior. This dual identity was evident in two legal cases involving threats to Lucca's sovereignty. In one case, the city faced the rule of Paolo Guinighi, and in another, a plot to bring Lucca under Florentine control. These cases, though different, were both analyzed through the lens of lesa maestas. The jurist Bartolomeo Ceccini used lesa maestas to unravel complex legal issues. He showed that this concept wasn't just a tool for repression, but also a flexible instrument to balance private and public interests. Lesa maestas helped solve legal puzzles in a way that could be seen as fair and just. This demonstrated that the law, even in times of crisis, could be a powerful and adaptable tool for maintaining order and justice. Ceccini's life and work are deeply intertwined with the city of Lucca, a place where he found both professional opportunities and personal connections. His relationship with Lucca began early, and it remained a significant part of his life, even as he traveled between different universities and faced various challenges. When Ceccini was teaching at the University of Ferrara, he met Filippo Corsini, a respected canonist from Lucca. Their friendship was more than just professional, it was a bond that lasted for years. This personal connection to Lucca's legal and political circles was further strengthened in 1483, when the Anziani, the city's leading elders, wrote to Ceccini. They appealed to him for help in preserving the safety of the Sienese regime, reminding him of the long-standing friendship between his family and the city. The Anziani believed that Ceccini's support was crucial, not just because of his expertise, but because of the trust and respect he commanded. In 1489, Ceccini was in Lucca when Luigi Venturi, an envoy from the University of Florence, approached him with an offer he couldn't refuse. Venturi promised Ceccini a generous salary of 1,500 florins a year to resume his duties at the University of Florence. This was a staggering amount for the time, reflecting the high regard in which Ceccini was held. However, even when he was offered such a lucrative position, Ceccini felt secure enough to leave his belongings in Lucca, a testament to the city's safety and his trust in its people. In 1495, Ceccini faced a significant challenge when he attempted to leave Pisa for the University of Padua. As he rode out of the city, he instinctively headed towards Lucca, a place he considered a safe haven. Unfortunately, he was apprehended by the local authorities and brought back to Florence, where he was imprisoned in the Stinch. While in prison, Ceccini was accused of stellionatus, a crime involving fraud, and lesa majestas, a serious charge of offending the state's authority. These accusations, whether true or not, highlight the complex and often fraught nature of political and legal life in Renaissance Italy. One of Ceccini's most significant contributions comes from his first concilium, a legal opinion that delves into the rarely explored dimension of lesa majestas as a charge against a tyrant. This charge, while theoretically well established in the works of jurists like Bartolus of Sassoferrato, was rarely used in practice. Ceccini's analysis helps to clarify the legal implications of tyranny, a concept that was often used more as a political tool than a legal one. The case of Paolo Gimignano, a prominent figure in Lucca's history, serves as a perfect example of this. Gimignano's rule, known as a tyranny by many, lasted only a short time before the city's communal institutions were restored. Historians like Niccolò Tucci and Giuseppe Civitale have painted Gimignano as a tyrant, but Ceccini's concilium reveals the complexity of the legal issues surrounding his rule. When Ceccini was asked to provide a legal opinion on the inheritance and property rights of Gimignano's brothers, he had to navigate a maze of legal and political questions. The treasury of Lucca argued that Gimignano's actions as a tyrant should result in the confiscation of his property. However, Ceccini, using his deep knowledge of the law, pointed out that the statutes of Lucca did not automatically strip Gimignano of his legal rights. Instead, he argued that the crime of lesa majestas, which Gimignano was accused of, would have to be proven through a judicial process. This meant that Gimignano's legal capacity to acquire and inherit property was not automatically nullified, and his property should be divided according to the rules of intestate succession. Ceccini's analysis also explored the broader implications of the concept of tyranny. He noted that while Gimignano's rule was often described as tyrannical, he did not necessarily act in a despotic manner. Instead, it was the fact that he had usurped power without a just title that made him a tyrant in the eyes of the law. This distinction is crucial because it highlights the difference between a ruler who is a tyrant by conduct and one who is a tyrant by the mere act of usurping power. In the end, Ceccini's work on the concept of lesa majestas and tyranny provides a nuanced understanding of the legal and political landscape of Renaissance Italy. It shows that the law was not just a set of rigid rules, but a dynamic field shaped by the specific contexts and challenges of the time. Ceccini's legacy is not just in the legal opinions he provided, but in the way he helped to clarify and refine the concepts that govern the lives of people in cities like Lucca. Lucca, with its rich history and complex political landscape, was a fitting backdrop for Ceccini's career. It was a city where the interplay of law, politics, and personal connections shaped the lives of its citizens. Ceccini's life and work reflect this interplay, and his contributions continue to be relevant to our understanding of the legal and political systems of the Renaissance.